This is Tuomas Pöysti, Chancellor of Justice of Finland, and I will here speak about our work regarding access to documents, access to data, and transparency in Finland. In Finland, the constitutional independent oversight by the Chancellor of Justice and the Parliamentary Ombudsman is complementing the work and oversight provided by the courts. And that's very important in the area of freedom of information. We have a constitutional right of access to documents and information from the public authorities. But of course, this is a difficult area where many times problems do occur. In Finland, the courts can review a decision of rejection if somebody has been denied an access, so one can appeal to an administrative court. But if there is no decision, or if there is a passivity, so the Finnish constitutional order is providing that a complaint to Parliamentary Ombudsman or a complaint to Chancellor of Justice are the principal remedies to rectify this. So we are mainly working with the passivity, where information has been requested and no response has been given. As part of that, we are promoting a culture of transparency, meaning that we also always, when we investigate an individual complaint of a lack of access, which are the organizational or information system reasons leading to passivity and delays, and try to foster a culture of transparency, an organization where access to information is given the priority it deserves in a society which is valuing high level of transparency. In recent days, however, there is also the other side of the issue. Access to documents is very good, but also at the same time, the authorities need to also ensure that issues which are falling under privacy or which are falling under national security or any legitimate exemption are kept really secret and safe, but that these exceptions are not interpreted too widely. And increasingly also our work is also focusing on this education and understanding which are the legitimate exceptions to access and on which cases in fact the priority should be given to access to information. This balancing is not always easy, and it benefits from this rather centralized guidance through our cases and through our systemic reviews we perform. In the current digital society, the issue is not only about access to paper documents. It also means that important information is documented, because many discussions do take place in social media or in different kind of digital platforms. So these should be also documented so that this access is not losing its significance. And also sometimes some algorithmic models like this forecasting models of be it climate change or pandemic spreading have a big impact on public life. So therefore also access to this kind of algorithmic models and generally speaking data is important. And there we have in our case law combined interpretation of the European Union Access to Data Directive with rather classical interpretation of our constitution's rules and provisions on access to documents in public administration. This is a fascinating area of law which requires constant attention in our daily work.